justice. Kyle Bishop is suing his former business partner, Bridget Pinder, for the return of ice cream equipment.
Court come to order. All rise.
Have a seat, please.
Judge, case 3137, Bishop versus Pinder.
Thank you.
Welcome.
Mr. Bishop, you and Ms. Pinder are both in the business of products that contain CBD.
CBD and THC, Your Honor.
CBD and what?
THC.
You have to tell me what that is. Some people don't know.
It's a cannabis derivative.
That's good for what?
It's good for pain management, sleep, stuff like that.
And your particular specialty was CBD's infused ice cream.
Correct.
And you take that for pain management.
You can.
What else do you take it for?
You can take it recreationally, too, if you want.
Just to be happy.
Just to be happy.
It would seem to me that that's why you would take ice cream.
Sure.
Just to be happy. How long have you been involved in that business?
Since 2018, Your Honor.
Just my own curiosity. How'd you get involved in the ice cream part of CBDs?
It was basically just a fun way to infuse the CBD or THC.
And how do you buy the CBDs? Does it come in a box?
It comes in a distillate. So it's comes in a liter jar.
A liquid?
Yep.
And where do they get that from?
They extract it from the plant itself.
And you buy it from a company?
Yeah, yep, the extraction company, yep.
Where are they located?
In Oregon.
Must be a good business.
Oh, yeah.
Okay, and you invested in this ice cream machinery. Mm-hmm. I assume there's no difference between the ice cream machinery to make ice cream.
No, none at all.
And the one to make
No.
ice cream infused with CBD.
None.
Okay. When did you purchase the equipment?
So the freeze dryer was purchased on February 22nd of 23. That was just one of the machines, one of the three.
And how much was that machine?
That machine was exactly $2,904.02.
Okay.
But there's also interest on it, because I'm doing a payment plan on it.
Just tell me what the second piece of equipment was.
Sure. And that would be a winter ice cream machine.
Okay, when did you purchase that?
This one was purchased on January 9th of 22. That was the second ice cream machine that I have.
And the third one?
I don't have the exact date, but I do have proof of purchase.
What was the year?
22.
Did you buy it from a private party?
Yes.
Okay. And how much was that?
That was $250.
Okay. And the one that you bought on January 9th, 2022 was how much?
$300.
$34.54 is what you paid for the equipment.
Correct.
You have any loans out on the equipment?
I do. Yep.
And that would be on the one you purchased in 2023?
Correct.
And how much is left on that?
I actually don't know. I just keep making payments on it.
When was the last time you made a payment on it?
This month.
Now, Ms. Pinder, you're in the same business, and what I gather was he leased some space and then he had some trouble in his space. You used to be in that space, and you were moving into new space.
We were already in new space.
You were already in new space, and he asked you if he could move his ice cream equipment over to your space and sell stuff out of your space.
Correct. We were going to collaborate. I'm sorry.
And when was that?
That was in July of 2023.
And that was the plan. He had his ice cream infused, and you are involved in CBDs. What kind? What do you sell?
So we grow, process, and make all of our own products. So we have a hemp farm where we grow all of our own hemp, and then we process it ourselves. So we get an oil, rosin out of our plant, and then we take that and we use that in our products. We were going to collaborate with Kyle on an ice cream product, and that is how we ended up
So she would supply the liquid?
No, she didn't supply anything.
No, she would.
Sorry.
I didn't say she did. I said if you're going to collaborate, were you going to buy your product from her?
We could, yes.
I actually did supply. Oh, I'm sorry.
Well, that sounds like a collaboration.
Right.
Right? Mm-hmm. I mean, if she processes her own liquid.
Right, but it's more cost effective to buy it in bulk the way I was doing it versus making it.
So how were you going to collaborate with her?
It was going to be a 50-50 partnership between the profit made.
So you were going to go into her space, make and sell your ice cream.
Right.
And she would get half the profit.
Right.
In exchange for your rent. Is that the deal?
We didn't have a deal on rent or anything.
Okay, so you didn't have a deal on rent, but you were going to split profits on his product.
Correct.
Okay, and there was a kerfuffle between the two of you when?
About July 26th, 2023.
And you were no longer collaborating after that?
Correct.
And you still have his ice cream equipment in your store?
Correct. And the reason that I have his okay.
And that's what he wants back?
Well, no, actually I do. I just want the value. I don't want the equipment anymore.
I don't care what you want.
Sure.
You want your equipment back.
Well, actually, I want the value of the equipment.
She's not going to pay you for the equipment. If I rule that she has to give it back to you, she's going to give it back to you. You got to go pick it up from wherever it is. Okay.
Bishop claims his former business partner, Bridget Pinder, is wrongfully withholding his ice cream equipment. Bridget is countersuing for the cost of CBD products and defamation.
Now, is a theory that you're holding on to his equipment, that he has some of your product?
Yes, ma'am.
So in effect, what you did was put a lien on his equipment, even though you didn't put a lien on it.
Correct.
You have to return his equipment.
Okay.
And you have 5 days to do that. You go there if you need to go there with a sheriff or a marshal. We'll put that in the order.
I've already done that once. I've already done that once, Your Honor.
Well, now you do it with an order. 5 days, you pick up your equipment. Okay. Now, you paid $34.54 for the equipment. Would you mind telling me why you're suing for $7,000?
Basically for damages done to the business as well.
What damages?
Loss in profit and wages.
How do you know that? What proof do you have of that?
I can't sell any product, Your Honor.
Well, what proof do you have of what you could sell?
I do have other clientele that would purchase.
How do I know that? You get your equipment back.
Okay.
Be happy. Now, she has a counterclaim. She says you have some of her product.
I do.
First, how did you come into possession of her product?
We agreed upon the old space that we were both currently at. It was a 60-40 split.
Just a minute. You mean in your old place that you left?
Yes. Yep.
Before you left the old space, she gave you some of her product for you to sell.
Right. And then I still owed on that product after closing.
Did you have a written contract?
No.
How did you keep track of what she had given you to sell?
We would basically just do it through the POS system.
The what?
The POS system, point of sales.
On my end, I would keep track of every time I would bring product out to the store, or one of my employees would bring product. And then I also have copies of my wholesale books and my lists, if you would like, so that you can see how much things cost. And
Mr. Bishop, I'd like you to take a look at this and see if this represents a fair and accurate representation of the product that Ms. Pinder gave you to sell on consignment.
These are the correct products, but not the quantity.
Do you have what the quantity is?
I do not.
Well, why don't you keep it? I mean, you're in business. If you don't have it and she has it, then I must rely on what she has. Mr. Bishop, you got to stop eating all that ice cream, sir.
No, I do have conversations.
You eat up all the product. You know, you're not in business anymore. So where is all of her product?
It's in storage right now.
How long has it been in storage?
About 4 months.
What's the exact date it went into storage?
I don't know, Your Honor.
July when he left his store. So
it was actually May 11th was the last day, Your Honor.
Okay, so I'm sorry, May 11th was his last day. And our products are not very shelf stable. They have about 6 months to a year shelf stability. So those products would not be viable anymore.
Tell me, Mr. Bishop, how come you put the products in storage in May?
That's just because we're transferring over to a new spot. Well, trying to anyway. And then we're just continually trying to find a new spot.
Well, what happened with her spot?
We had a fallout, so.
He was never coming to my new spot. His old spot is where that I was in prior to him renting it. So we've never been in business together. We've never had like a spot or anything like that together.
But that was the plan.
No, it was not.
That was the plan.
The plan was for him to make ice cream in our processing facility, but not for us to ever share storefront together.
So his ice cream equipment was placed by him in your processing facility, not the store?
Correct.
So he never really used it to make ice cream.
No, I asked him multiple times in multiple text messages to come in and make the product because we were supposed to be making a product together. And he would always give me excuses like, I don't have gas money, I can't get there today, this and that. And then the product not being viable, we also went back and forth with that. I kept asking him to make something with a longer shelf life, things like that. So that didn't happen.
May I see some of the text messages?
Yeah. Here's.
And then I'd like you to tell me.
So these are in order. This is from where we were talking in July 26th. So this is me asking for my products back. Maybe we'll start with that. I don't know. I don't know if you want the whole thing.
Yeah, okay. I want everything. The defendant said to you, I'll need my products back and money you owe me first. I assume you asked for your ice cream equipment.
Correct.
I've been asking you for weeks when you're coming in, and you didn't, so now I don't have time. Well, how much did you owe her in July? Mr. Bishop, you clearly, based upon all of these messages, owe her money.
Correct.
And you owe her some serious money in July. And what you're doing is saying to her, listen, I'm not doing well right now, so you got to stop stressing me. You're asking her to be like your mother. I owe you money, but don't talk to me about that now because I'm very stressed.
There was only
and I have to make money, and I need my freezer equipment to make money, and you won't give it to me. That's what you're saying to her. Now, he says to you, I know I owe you $700, and it's just frustrating that the faucet just shut off. Trust me, I know. But we need to work together on this to make it work. There is a spot in Glencoe for $800, all utilities with a small kitchenette, and only asking for 1 year's rent. I can sell things and do DoorDash to meet that.
The $700, Your Honor, that was for product he had sold in the store, not for the product of mine that he still has. So I agree
so
that
what he
was selling our products.
That's not right, Your Honor.
So that was the $700 that he had sold that he owed us from selling the product, but he still has all of my other products in storage.
He has other inventory.
Yes.
Okay. Mr. Bishop, I'm reading all these messages, and it appears that you said to her, I owe you $700.
Correct.
Now, in my rudimentary business mind, that means that that is not materials that you had of hers that are currently in storage, but materials that you sold and were her part of the profits. You said it was a 60-40 split in the old store.
That was for the collaboration we were going to do.
No, that's for what you sold already. That's for what you sold, and you didn't pay her.
But there's no way I have $10,000 worth of product. There's absolutely.
Well, but you see, I don't know that because you just took it and didn't keep inventory. You just took it. Gimme. I want to make some ice cream.
Has accused his former business partner, Bridget Pinder, of refusing to return his ice cream equipment. Bridget is countersuing, claiming Kyle owes for the cost of CBD products.
So my question to you, Mr. Bishop, is how much money did you owe her?
Only $700, Your Honor.
I want you to show me how you get to that figure.
Sure.
Your Honor, that was this.
There's her. Oop. Excuse me, sir.
What you're showing me is $700 that you already owe her for products that you sold.
Right, but that's all that was owed.
Well, what's in storage?
It's about like $500 worth of product. It's not much.
That's not what she says.
Right, that's what she said.
Why didn't you give it back to her?
I mean, we tried talking. I even brought a cop for a civil standby. We couldn't really work it out.
What do you mean you couldn't work it out? Why don't you just give her back all the products that you had back in July? They were still good.
Well, I was going to sell those in my new spot. I thought I was going to get a new spot by next month, but that never panned out, unfortunately.
Well, that's not her fault.
Right.
You kept stuff that didn't belong to you.
Right. But I do have text messages saying that I was going to sell that in the new spot.
But you didn't.
Well, I can't.
Why?
Because I don't have a new spot.
Well, that's not her fault.
Right. No, I know it's not.
You've been eating too much ice cream, Mr. Bishop. Try chicken and fish. It'll help you out a lot. It's good for your brain.
Your Honor.
What?
He's also been defaming us on social media and YouTube which I have copies of. He also has product with our logo on them still on his Facebook page that we've asked him to take down multiple times, which he hasn't, and he laughs at us about.
Merci.
Yeah. The picture of the YouTube, Your Honor, is him sharing our text messages that I gave you on YouTube, calling us thieves.
Okay. I was saying, if you don't want to see the picture on the front page of the New York Times, don't take the picture. And if you don't want to see something republished, don't send a text message about it, because it can be republished. I don't know what this means. Can you get away with stealing? #law, #education. What is that?
The content of that was actually a guy stealing a watch, and then the state pressing charges against the guy that stole. So telling her basically that the state would press charges against her for stealing my stuff.
But taking my business.
She actually should not have retained your stuff without the intervention of a court, but that's why we're here now, sir.
Correct.
And the defendant says that the value of the merchandise that you have is not, as you speculate, $500 or whatever, but more in the neighborhood of, she says, thousands of dollars, because you're suing for a congregate amount of $10,000. You break that up in product and in defamation. Now, you have a fixed amount that I can see of what products you gave him, when, and your cost on them. Do you have that?
Yes, ma'am.
I'd like to see it.
It's on the back sheet of the one that I gave you, 11,000, the one that looks like this, Your Honor.
Okay. You asked him for his stuff.
I did.
Mm-hmm. Do you remember what he told you?
He told me that he was going to be getting a new space and that he was going to sell my stuff in his new space. So I asked him multiple times for my things back, because I know that they're not going to do well in a storage space. I even told him, give them back to me, and I will give you new stuff when you open your new space.
That's not true, Your Honor.
It is true, Your Honor. That's what
There's no text messages saying that.
No, I told that to him.
It really doesn't matter, does it?
Yeah, because I wanted him to succeed. I'm in the part of our huge part of our community.
That's not true, Your Honor.
And
Don't interrupt her.
I wanted him to succeed. I want a lot of people to succeed, and so I try to help others in our community, and that's what I was trying to do here, Your Honor.
She actually had a lobbyist group make my product illegal. I don't know how that's helping me.
Mr. Bishop, let me ask you this question. You're coming to court today
Correct.
asking for the return of your equipment.
Correct. But now I can't even make the product because it's illegal now.
Because it's illegal.
Correct. She made it illegal.
Wow. She's not a legislator. She may have lobbied to make it illegal, but she's not a legislator.
Well, no, she used a group called that.
I don't care, Mr. Bishop. You have to understand. I don't care. What I'm saying to you is, you're coming into a court of equity and you're saying, I want my equipment back, which I can still use because it's equipment. And
Well, I
Ms.
can't
Pinder,
use it to make ice cream.
I don't care what you use it for. You can use it to make ice cream, so you just can't make it with CBD infused ice cream.
Correct.
Make as much ice cream as you like. And as far as the defendant is concerned, if you can't make CBD infused ice cream, she has no use for the equipment.
Correct.
Except to sell it. But if you can't use it, is that right?
Correct.
If you can't use it, then you really don't want it back.
Correct.
Then I'm not going to give it to you back.
Okay.
And I'm going to take off the value based upon what you owe her, because she can't use the product anymore. Its shelf life is gone, and you've retained it. Do you understand?
Correct.
So she says the value of her product is $11,000. My court maximum is 10. She's got the equipment that you can't use. I don't know what she can sell it for. You paid $3,000 for the equipment. You have $10,000 worth of stuff that you can no longer use because he's retained it in storage. Sell whatever you can of his ice cream equipment.
Okay.
I'm awarding you $7,000 on your counterclaim.
Thank you, Judge.
The plaintiff's claim is dismissed. On the counterclaim, $7,000. Thank you.
Thank you, Your
Court is
Honor.
adjourned.
We just had a disagreement, unfortunately. We had a bit of a falling out, so.
He wouldn't show up to make the product. The shelf life on the product was not long enough, and it wasn't reliable.
They put in law that my ice cream is now illegal, so.
We did not do that. We did not get anything banned. We worked really hard to get THC legalized in Minnesota, and that's what we did.
Oh, we're just gonna move forward.
We will never work with him in the future.
I should have asked whether these products that contain the CBDs that she sells, that he took and has in storage. I wonder if they have an expiration date.
A lot of them do. I think it's a plant derivative. Sometimes, balms or salves that have CBD in them do all have an expiration
date on it.
Just because they do come from a plant derivative, so they have some form of expiration
date. Yeah, you see that, when products that you buy in the grocery store.
It sounded
that's
accurate
used by.
when she said 6 months to a year around.
Yeah.
But yeah, it would have been a good question.
I had finished the piece, and when I woke up in the morning, the painting had clearly been clawed up by the cat.
You chose to go there. You knew that there was a cat there.
I was assured the cat would not be able to get up on the counter.
Why didn't it go in a closet?
I don't know.
I don't know.
This is Judy Justice. Artist Tara Rule is suing Timothy Reedy for property damage due to his negligence.
Court, come to order. All rise.
Have a seat, please.
Case 3136, Rule versus Reedy.
Thank you.
You're welcome.
Miss Rule, are you an artist by profession?
Yes.
Is that how you earn a living?
Yes, Your Honor.
Any other job? Your complaint is this. You allege that the defendant, with whom you briefly dated, is responsible for the loss of a piece of artwork that you had done on commission.
That's correct, Your Honor.
So let me get a little background. You were commissioned to do, according to your complaint, a painting for whom?
A photographer that I know, they were going to use it as like a background piece for, I don't know, some kind of photography thing he was doing. I don't know exactly what it was for, but.
Had you ever done any work for him before?
No.
And you were given certain instructions by this person?
Correct.
You agreed on a price, which was?
$4,000.
And according to your complaint, he gave you, it was a he, correct?
That's correct, Your Honor.
He gave you $2,000 to begin the work.
Correct.
Then you were almost finished with the work, and he gave you the other $2,000.
That is correct, Your Honor.
And you have proof of those payments with you to show me.
I do.
May I see them, Kevin, while we're continuing with the case? And I'd like you to tell me during what period of time you did this work.
The initial conversation that I had with the client was on December 1st, and I actually ended up finishing the piece on December 9th. The incident happened...
Just a second.
Sorry.
You finished the painting on the 9th, so it took you about a week.
Yeah, correct.
Okay. When were you supposed to deliver the painting, or was he going to pick it up?
I was going to drop off the painting to him on February 1st.
During what period of time were you and Mr. Reedy dating?
Not for very long, from approximately the 21st of January until the incident.
Which happened on?
The 1st of February.
Now you can tell me what happened.
I had finished the piece and...
May I see it, please, by the way?
Yeah, certainly.
I assume you have photographs of it. I assume you sent it to the purchaser.
Yes.
Beautiful.
Thank you.
It's an oil on canvas?
That's correct, it's oil. Mm-hmm.
Go ahead.
I had finished the piece and I brought it over to the defendant's house because the defendant lived closer to the client.
On the 1st?
The day before. I was spending the night.
Okay. So you arrived at the defendant's home. Tell me what kind of home he has.
An apartment with
How
a roommate. Small 2-bedroom.
Go ahead.
The defendant has a cat. She's a kitten, so she's a little bit rambunctious.
Had you spent the night at the defendant's before?
That's correct, Your Honor.
You had?
Yes.
How many times?
Maybe about 6 or 7 times.
And the kitten had always been there?
That's correct, Your Honor.
Okay, go ahead.
I had some concerns about the kitten getting into the painting upon arriving. It wasn't something I really thought about too much until I got there. So the defendant and I decided to put the painting up on a counter because the kitten can't really get up on the counter. There's a bunch of stuff on the counter. So we figured if we put it kind of further back, kitten would not be able to get to it, and that would keep it protected overnight. I don't know.
Why didn't it go in a closet?
I don't know.
I don't know.
I don't know, Your Honor.
It seemed to me that if you really wanted to protect it, you would put it in a closet.
The closets that I was aware of were blocked off by items.
You mean there were things in the closet?
Outside of the closet.
You mean you couldn't get into a clothing closet? Where did you put your clothes? You spent the 6 or 7 nights there. Where do you hang your clothes?
I would put them in a reusable grocery bag and leave them on the floor.
Okay, great. Go ahead.
So I don't know exactly what transpired, but something happened in the middle of the night where the defendant moved the piece, I guess, to get something and placed it on the floor, kind of propped up against a wall, and didn't put it back on the counter. And when I woke up in the morning, the paper that I had on the outside of the painting to protect it had clearly been clawed up by Nina, the cat, and the painting itself was torn.
And you returned the money.
I did. I talked to the client. Sorry.
You had to return the money.
Yes, that's correct, Your Honor.
What'd you do with this painting, by the way?
I actually destroyed it, and I used the wood frame for something else.
Do you want my version of events? Mm-hmm. Oh, I mean, it's basically the same, but I didn't move the painting. I didn't touch the painting. I never touched it.
It was on the counter.
It was on the counter.
Have a photograph of the counter? No.
I don't have a photo. I have a photograph of my cat.
No, I don't care about the cat.
You don't care about my cat? She's a cute cat.
I care about the cat. I care about the cat. It's not that I don't care about the cat. I'm not engaged with the cat. It has, other than the fact that it's a kitten and that it destroyed the painting, I'm not interested in seeing a picture of the cat. Why do you think it's his responsibility? It's your responsibility. He doesn't have any responsibility with regard to your work. You're a big grown-up person. You want to protect your work. You leave it in the car, lock it in the trunk, put it in a closet. Why is it his responsibility? Maybe his roommate moved it. And even if they did, it's their apartment. It's your responsibility to keep your property safe.
First of all, may I just say that the defendant and I had conversations about the fact that he did, in fact, move the painting.
Okay.
And that it wasn't his roommate. But furthermore, the discussion that I had with the defendant was like, I'm concerned about the painting. He was, I thought, sharing that concern. And it was assured to me that nothing would happen to it. While at his home, he's responsible for his cat.
No, he's not. You're responsible to take care of your painting.
Artist Tara Rule claims Timothy Reedy owes for property damage after his cat destroyed her painting.
You brought it into the house. He didn't assume a bailment of that painting.
I didn't want to leave it in the car.
You're a guest. If you didn't want to leave it in the car, it was your choice to go to his house. Listen, Miss Rule, you know that he's got a kitten. You've been there 6 or 7 times before. I believe the word she used was rambunctious.
She did, rambunctious.
That the kitten you knew was rambunctious. You also knew that the kitten had claws. You knew that sufficiently so that you said to yourself, oh, gee, where can we put this so that the kitten can't get it? Well, having been a cat person at one time in my life, they can get anywhere. How old is this kitten?
About 6 months.
6 months, they can get anywhere. I had a cat whose name was Shirley, along with about 4 other cats. But Shirley was a yenta. You know what a yenta is? Busybody, liked to get in everybody else's business. And her joy when she was a kitten, maybe 6 months old, was jumping up on soffits and watching everybody, watch the other cats. Watch me, it was spooky. But you know that kittens can do damage, madam.
Certainly.
It's your responsibility. That's not his responsibility. You chose to go there. You knew that there was a cat there. You put the painting up on something. I mean, even if you put it over, turned it over so that it was face down, if the cat scratched it, it may or may not have gotten it. But I don't understand why you think it's somebody else's responsibility to take care of your property.
Well, respectfully, Your Honor, it's because we had this conversation about, I was assured the cat would not be able to get up on the counter, and he moved it to keep it safe.
Oh, come on.
I wanted it there.
If you were there 6 or 7 times, you've seen the cat up on the counter.
I've never seen the cat on the counter, Your Honor.
Well, then you weren't looking carefully enough.
I was assured by the defendant that the kitten could not get on the counter.
It's your responsibility. It's not his responsibility. It's your responsibility to take care of your own things, not his. The case is dismissed. We're finished.
This court is adjourned.
Thank you, Your Honor. Thank you.
I had already served nearly 3 decades on the bench when the case of Michael Ray's was assigned to my courtroom. By then, I believed I had grown immune to surprises. Murder cases no longer shocked me. Fraud no longer angered me. Domestic disputes no longer unsettled me. But this case followed me home every night for months. The charge was second-degree murder. The victim was a 42-year-old man named Thomas Green. The defendant was 19-year-old Michael Ray's. The incident had taken place in a quiet neighborhood on the outskirts of town. According to the police report, Thomas Green was found dead in his living room with a single gunshot wound to the chest. There were no signs of forced entry. The weapon was recovered at the scene. It belonged to Green himself. Michael Reyes had called 911. When he was brought into my courtroom for the first hearing, he looked more like a high school student than a murderer. Thin frame, trembling hands, eyes that refused to rise above the defense table. The prosecutor painted a simple picture. Your Honor, on the evening of March 12th, the defendant went to the victim's home. An argument occurred. The defendant took the victim's firearm and shot him at close range. This was intentional. The defense told a different story. Michael Reyes had been visiting Thomas Green's house for nearly a year. Green had been a close friend of Michael's late father. After Michael's father died in a construction accident, Green offered to help the family. He paid for groceries. He drove Michael's younger sister to school. He slowly became part of their lives. No one questioned it. Until the night everything changed. When I asked Michael if he understood the charges against him, he nodded but said nothing. The trial began 3 months later. The prosecution presented their evidence first. Phone records showed that Michael had texted Green earlier that day asking to meet. A neighbor reported hearing shouting before the gunshot. Gunshot residue was found on Michael's hands. He did not deny firing the weapon. Ladies and gentlemen, the prosecutor addressed the jury, this is not a mystery. The defendant went there angry. He shot the victim. This is murder. Then the defense stood. The defense attorney was an older woman with calm eyes and a steady voice. Michael Reyes did fire that weapon, she said, but the story does not begin that night. She called Michael's younger sister, Sophia Reyes, to the stand. Sophia was 15. She held the Bible with shaking hands before taking her oath. Her voice was barely audible at first. Mr. Green used to come over after my dad died, she said. He said he was helping us. The courtroom was silent. At first, he just brought groceries, then he started asking me to stay after school at his house to study. The prosecutor objected, but I allowed the testimony. Sophia's words came slowly, painfully. He told me not to tell Michael. He said we needed his help. Tears streamed down her face. The defense submitted messages retrieved from Green's phone, inappropriate texts, requests for secrecy, photographs that should never have existed. The air in the courtroom changed. Michael had discovered the messages the night of the shooting. According to his testimony, he had confronted Green. An argument escalated. Green allegedly laughed and said, "She needed attention, I gave it to her." Michael admitted he lost control. "I grabbed the gun from the table," he said, voice cracking. He tried to take it back, it went off. The prosecution argued that this was revenge, not self-defense. "You had time to leave," the prosecutor said. "You chose to shoot." Michael looked at the jury. "I chose to protect my sister." The medical examiner testified that the gun was fired from approximately 3 feet away. There were bruises on Michael's forearms consistent with a struggle. The case was no longer simple. The jury had to decide, was this murder, manslaughter, self-defense, or a tragic explosion of anger? During closing arguments, the prosecutor insisted, "We cannot allow individuals to become judge, jury, and executioner. No matter how horrible the allegation, the law must prevail." The defense replied, "The law also recognizes human limits. Michael Reyes is not a predator. He is a frightened brother who walked into a nightmare." The jury deliberated for 4 days. When they returned, the courtroom was packed. On the charge of second-degree murder, not guilty. On the lesser charge of voluntary manslaughter, guilty. A murmur spread through the room. Sentencing was mine to determine. Under the statute, Michael faced up to 15 years in prison. Before sentencing, I allowed him to speak. He stood, hands trembling. "I know I can't bring him back. I know what I did was wrong. But when I saw those messages, when he smiled like it didn't matter, I felt like something inside me broke. I didn't think about prison. I didn't think about consequences. I just thought about my sister." Sophia sat in the front row, holding their mother's hand. I looked at Michael for a long time. The law is clear, anger does not justify killing. But the law also recognizes provocation. I delivered the sentence slowly. "Michael Reyes, this court recognizes that you acted under extreme emotional disturbance. However, a life was taken. The appropriate balance between justice and mercy must be maintained. I sentenced him to 5 years in prison, with eligibility for parole after 3. Gasps filled the courtroom. Some believed it was too harsh, others too lenient. Michael closed his eyes. His mother wept quietly. As deputies led him away, Sophia stood and whispered, "I'm sorry." He turned to her and said, "You don't have to be." 3 years later, I received notice that Michael had been granted parole for exemplary behavior. He had completed anger management programs and was studying law in prison. I sometimes think about that case. The law demands order, but life brings chaos. That day, the courtroom did not just judge a crime. It confronted grief, betrayal, and the fragile line between justice and vengeance. And I was reminded once more that sometimes the most difficult cases are not about deciding guilt. They are about deciding how much punishment a broken heart deserves.